Right, are you Keyshawn Purdy? And so it looks, Ms. Purdy has two cases. She's on probation and cause number 24 DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And then there is new offense
Injury to insurance.
and cause number 25 DCCR 1523. And we had Miss Purdy was here before and entered a plea of true to failing to perform the community service hours, but not true to all of the other allegations in that motion to revoke. And we had reset it today for sentencing. And I got that updated pre-sentence report. It's my understanding that you guys have now reached an agreement for both of the cases. Is that correct?
Yes, Your Honor. Yes, Your Honor.
And good morning, ma'am. Thank you for being here. Probation is here for the record. So let's first go through the new case and then we'll go back and make sure we've got everything done on the other. Will she waive the formal reading of the indictment?
So moved.
Ms. Purdy, in cause number 25 DCCR 1523, you're charged with the state jail felony offense of injury to a child, and that's from September 28th of 2025. How do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached in this case is for a 3-year deferred probation. There would be a $250 fine. You would be required to follow all of the rules and conditions of probation. And part of that agreement would be that your probation in the other cases continued. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Ms. Purdy is not competent?
I've observed no evidence of her incompetence. I believe her to be competent.
Okay, thank you. I'm just, because we didn't do a pre-sentence report on that
Your Honor,
case, I think
I would ask that we
might
just
need one.
use the report from probation, the updated report in the probation case. Honestly, the reviewing that was part of the reason we worked this out in this manner. Your Honor, without objection. Unless you want some clarification.
Well, I guess what I want is so this updated report addresses some things about the batter's intervention and things like that, but not the fact that she was discharged from drop after not showing up. And so apparently if there is a drug issue, I want to know how we are going to address that. Any suggestions before I make
She's
my,
currently on the drug patch
okay.
because of her discharge from drop.
Have there been any positives since she's had the drug patch?
Yes, yeah.
And it looks like she was on that, but it was inconsistent for at least some time with maintaining it. Is that correct also?
Correct.
Awesome.
I was working day and night and mixing up days.
Can't mix up days when you're on felony probation.
Yes, ma'am.
This is one of the biggest moments in the hearing. Judge West isn't just accepting a guilty plea, she's making it crystal clear that probation is a privilege, not a right. One more mistake, one missed requirement, or one failed drug test could turn this second chance into prison time. Do you think the defendant will finally change? Or is another courtroom appearance inevitable?
Right?
Yes, ma'am.
I mean, and I don't mean to say this flippantly at all, but I mean, if you end up messing up again, and I go along with this now and you mess up, your days and nights are gonna be a whole lot different.
Yes,
You'll
ma'am.
know exactly when it is because somebody else is going to tell you when to wake up. Somebody else is going to tell you when to go to bed, all those types of things. And that's not what you want. And that's not what we want for you. But you have to follow through with everything on probation. You don't get to pick and choose. You don't get to say, I got my days mixed up. It's obviously very important based on the nature of what you're charged with, based on what you're on probation for already, that we make sure that you're not using anything you're not supposed to. So then what I'm going to do in 25 DCCR 1523 is waive the pre-sentence report since we have that update and probation's here and willing to work with you. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that is there any evidence that she's not competent?
No.
Right. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings, place you on probation. Sorry, my computer just got for 3 years. Order that you pay the $250 fine, and again, follow all of the rules and conditions of probation. Right now, that's to have a drug patch. And whatever probation feels like is necessary to be able to make sure that you're clean. That's going to be part of your probation. If it's the drop program, then you got to get back in it and show up when they tell you. If it's the drug patch, you have to wear it at all times, get it changed when you're supposed to, and everything like that. You understand?
Yes, ma'am.
All right. So then let's go back through. Clause number 24 DCCR 1272, which is the motion to revoke probation case. And go back through those allegations and get new pleas to those allegations. Okay, so in 24 DCCR 1272, I'm going to go back through that motion. You previously entered a plea of true to count 2. So let's go back through. Again, you're on probation for the state jail felony offense of unauthorized use of a vehicle. That probation was from July 22nd of 2024. It was a 3-year deferred probation. Count 1, which you previously entered a plea of not true to, alleges that you committed the new offense of injury to a child September 28th of 2025. And how is that true or not true?
True.
Okay. And then you pled true to count 2 already, which was the community service. Count 3 alleges that you're behind in your court assessed fees. Is that true or not true? They're paid up. That's okay. That's fine. So did you enter your plea of true to count 1 freely and voluntarily?
Yes,
And because that count is actually true.
yes,
And so the agreement in this is just to continue probation. Is that correct?
Yes, Your Honor. Contingent upon the deferred.
So here's what I'm going to do, Ms. Purdy. I'm going to find that you entered your plea of true to count 1 today and count 2 previously freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow this agreement, give you this opportunity to prove that you can do everything you're supposed to. And I am going to order as a condition of this probation the same thing, that at this point you have the drug patch or whatever probation thinks is necessary to make sure you're clean. And if that means drop or JCDI or whatever, then you would be required to do that. I am going to extend your probation in this case by 1 year. And Everything else is the same. So you now have two excellent opportunities because you're on two felony probations. And I want to make sure you understand if you're back in here after us all giving you this opportunity and probation willing to work with you, it's not going to go this way again. Okay. So make sure you do everything you're supposed to. There's no reason for me to believe that you can't. You just have to make sure that you make this all a priority. It's great that you're working. We want you to be working, obviously, but you have this responsibility that is just as important. Okay.
Yes, ma'am.
I'm going to hand you in each of your cases the trial court certifications that shows that these were all agreed. And so you've waived any right to appeal. If y'all will sign this one and take those bottom two copies and give me back the top two. Thank you for being here, ma'am. And thank y'all for looking that up.
Yes, sir. That's right. Oh, it's your turn.
Yep.
That's your copy.
There you go. All right. Good luck to you, man.
Thank
So again, you're Darian Broussard.
Yes, ma'am.
And so, Mr. Broussard, you're here in my court in cause number 25, DCCR 1441, and charged with, hold on a second.
It's right now.
You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle. And I've given you some time to try to hire a lawyer. Well, hang on, that's not even what my biggest concern is at this point.
Yes, ma'am.
Because you're already on misdemeanor probation. And for some reason, you've been testing positive for THC since last October while you were on that probation. And they let me know that, but I don't know why they haven't filed a motion or done anything about that. So
I paid it off, and that's what the judge almost told me to pay it off, because he was like, I don't know why you're still going to probation.
you're still going to probation because you're still using marijuana while you're on probation and while you have a felony court case pending, right? So I don't know what makes you think that that's okay, because it's not. And the fact that you were on probation and doing that, and now you're still doing it.
I wasn't still doing it. I was telling my probation, I was smoking wax, resin, pure THC, and I was telling him that I was doing it 30 days. It was kind of hard to come out of my system still. And I told him I needed another 30 days. He said, all right, come back May the 7th. Because he was like, it was going out the system, but I don't know.
But you've been doing it the whole time, right?
Yeah, I was doing it the whole time. Then when I got out, I stopped, and it was still in. I got out, I went to jail.
You got out. What'd you go to jail for? This?
Yes, and I got out like 3 days after that.
So you're telling me you haven't used since you've been to jail in this
Yeah.
case?
And the only reason it's still in my system because I smoke wax in the bone, like liquid THC. And I
Okay.
explained that to my probation officer. He explained it to the superintendent. She was like, "It probably take 120 days or so because it's pure THC."
He's been out since September. You've been out of jail since September?
No, yeah, no. I went to jail since I went out of jail since November.
It's April.
If I'm not mistaken.
Yeah. Okay. So I'm going to find that you have violated the conditions of your bond.
I didn't violate it.
There's no way it's still in your system if
I'll-
stop talking because you're going to make it worse.
Yes.
Okay. There's no way. I don't care what you're smoking out of it, whatever you're smoking it out of. Hang on. Because if the last time you did that was in September of last
No,
year
so
or November of,
no, it was January. That was my last time because I was like,
so you're not, see,
I'm
here's,
sorry.
you're not telling me the truth.
Yes, ma'am. I'm saying my last time when I got out of jail was in November. That was the first day I got out November the 1st.
Hmm.
I didn't go report till I think September. Yeah, September. And I pitched 30. And then I pitched 30 3 more times after that. And I told him, I was like, sir, I was smoking hardcore THC. I didn't smoke
None of
bud.
none of that would make you test positive today.
I tested positive again.
Why do you think we're having this conversation? Yes, you tested positive.
Keep testing positive.
Well, because you keep using. Come on now. Here's what we're gonna do. I'm gonna make sure that you're not using at least for some amount of time.
I'm not you, Miss West.
I'm going to raise your bond for violating your bond conditions. The fact that you've been using while you're on probation and they let you keep going makes no sense to me. Hold on, makes no sense to me at all. I'm going to raise your bond in your case for violating the condition of your bond. Hold on a second. To $50,000. Condition of that bond, if you make it, is that you will be required to have a drug patch on at all times.
Told him that from the
And-
first time. I told him that. I said,
Listen.
"Listen, patch." I'm serious, Miss West.
Okay, well, now you're gonna get one. So if a drug patch is what's gonna make you stop using, that doesn't make any sense either.
Not being stopped. That's what I'm saying.
Okay, I don't believe you, so I'm gonna make sure of
That's
that,
understandable.
because it doesn't make sense what you're telling me on the dates. So again, you have to have a drug patch on within 24 hours of your release if you make that bond.
I'm not.
And so if you don't make the
I
bond,
can't afford it.
you're going to get a court-appointed attorney. I will consider at some point, and we'll let that attorney know, reducing your bond back down after I know you have sat for some amount of time and not used. All right? You can go back with the bailiff. All right, you tested negative, Ms. Davis, which is obviously good. So tell me again where you are on being able to hire one of those attorneys. Are you going to be able to afford one of those that you talked to?
Yes, I want to say I have help with my father. It's just with the paying the bonds and stuff
Right.
like that. I have to honestly call him, and he said if I can get a bond reduction, he can be able to afford it.
Right. Well, we're not going to do that, but are you working?
No, ma'am.
Why not?
Well, I went to jail. I was working.
When did you get out of jail?
I'm ready to say day.
March, about March 2nd, maybe? Does that sound right? Last
Yes.
month?
Yes, ma'am.
Okay, so, as you,
But you say no to the bond reduction.
give me a minute to go back through some of this so I can remind myself.
Okay.
So you tested positive in court in January. When you tested positive in January, is that when I raised your bond?
No, that was the first time I came here.
So then you came back and
It
you
was
got the
drug
drug
patch.
patch and you were
Mhm.
testing positive on the drug patch, so I raised your bond
Yeah,
after you tested positive. in
it was
court.
the
So at this point, I'm not gonna reduce your bond. If you can't afford an attorney and you've tried, then I can have you fill out the paperwork for a court-appointed attorney. But based on the fact that the history you have with testing positive here, testing positive again after I gave you that opportunity to be on the drug patch, I'm not gonna reduce your bond. Do you want to fill out the paperwork this morning to see if you qualify for a
Yes.
court-appointed lawyer? So you're gonna fill it out. Make sure that you fill it out accurately and completely because you're gonna swear under oath that it's all true, correct? And then you take a look at it. Step in front of the clerk on the end, she'll give you that paperwork. Morning, are you Bonita, Green?
Yes, ma'am.
I mean Graham, I'm sorry.
Yes, ma'am.
And do you also go by Green?
Yes, that's my maiden name.
Okay. And so, Ms. Graham, you were previously in court. You're on probation in cause number 23, DCCR 1828, and then there was a new offense in cause number 25, DCCR 0734. You entered a plea of guilty in the new case, and also it looks like pleas of true in at least some of the allegations in the motion to revoke. There was no agreement. I received that pre-sentence report. Have both of you had an opportunity to review the report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections?
I reviewed it with Ms. Graham. If the court has any additional questions, she does accept responsibility in hopes of.
How so? Other than saying it when she was here last time. So here's the thing, Ms. Graham, you don't get to come in and say you plead guilty if you didn't do it. So what it looks like you told the probation officer is that you didn't do this. Is that correct? So why would you have pled guilty when you were here before, when you were under oath, sworn to tell the truth? I asked you very specific questions about, did you in fact do what they charged you with? And are you pleading guilty freely and voluntarily and things like that? Why would you have done that if you didn't do it?
I think it was just a lot of fear of what would happen either way.
So well, I mean, either you did what they said you did or you didn't. Did you do it or
I
not?
did not.
Then I'm going to reject the plea agreement. Your case will go to trial. There will not be any plea agreements accepted after this today. So we'll figure out a trial date. Ms. Holmes, you're appointed.
Yes, Your Honor.
So Ms. Graham, Ms. Holmes obviously is appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
I'm sorry to interrupt the court.
Sure.
Before we go any further, will the court entertain putting this case on hold just briefly? I mean, there is a video in this case. And it's my understanding is this offense was captured on video. I don't know.
Have y'all
if that's
taken a
been
look at that?
pressed upon this defendant.
And you've looked at it with your client?
I have.
Okay,
Well, with that being said, just never mind.
okay. I noticed that as well, that it looked
Yeah,
like at least that's the,
She came in my office, we reviewed the video.
all right, so we'll let a
Reminded,
jury,
yeah.
we'll let a jury decide. So the underlying offense is the same that she's on probation for. I don't want to waste time on an MTRP and then the real case, or I mean,
I
typically
prefer to
we'll
go
go
forward.
forward on the MTRP
Yeah,
if
I
it's
prefer-
one that's,
UTRP.
there's no reason not to. The case isn't more serious and won't take that long to prove up. So what I'm going to do is set this, and Ms. Holmes, because it'll be on the MTRP, I'm going to leave you on that. We'll set it for a special hearing, half a day enough?
Yes,
Think? Any issue with that? You think half a
No,
day?
that's fine.
All right, so we'll set it as quickly as we can on a hearing on that motion to revoke, and then we'll see where we get on that, and then we'll go forward with the other case, the new case, if need be at that time.
Yes.
Stay in touch with Ms. Holmes. She'll let you know when you need to be back. You need to visit with her before that court date because there will be witness testimony, and then we'll hear that motion to revoke and go from there. Obviously, I think what I will also do, based on the nature that I'm rejecting the plea agreement, I'm also going to withdraw or allow Ms. Graham to withdraw her pleas of true in that motion to revoke. And Mr. Coleman, if you can, I think that it would be best, probably cleanest if you just brought witnesses to prove whatever you think you can up.
Yes, Judge.
Okay, all right. You're free to go. And Mr. Coleman, this is yours on Aiden Dickinson. Good morning, sir. You're Aiden Dickinson.
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the
I
indictment?
will, Your Honor.
I'm getting there, sorry. Guys. All right, Mr. Dickinson, in cause number 25 DCCR 1480, you're charged with the state jail felony offense of engaging in organized criminal activity from September 28th of 2025. And how do you plead to that charge? Guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yeah.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including having no contact with the co-defendants, the other people involved in this. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes.
State tenors number one.
No objection.
It's admitted. Is there any evidence that Mr. Dickinson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report. It'll just give me more information about you, your case, make sure we have everything in place for probation and anything like that that you need. And then we'll go forward with sentencing at that time. You need to stop and talk to the probation officer before you leave the courtroom today. And she's sitting at that desk right over there. All right. See you back at sentencing. You're free to go.
She don't talk to you.
Okay, why didn't we? I feel like we knew this, but then we just pled and didn't talk about it at the plea.
It was set for a contested hearing and we brought it up and we tried to talk about it on a couple of different occasions. Then we got to put today's docket so we can figure out what we can or what we can't do. I don't know.
Well, obviously I don't know because I didn't look it up and try to figure that out last week. So I'm going to reset it again for 2 weeks. I need everybody to do some research. I will do my own research to see if there's a way to go back and adjust that from straight to deferred, which would make it correct, or if